A webinar on civilian hackers in state conflicts, legal status, rules of engagement, and obligation of states, hosted by the Center of International Law at National University of Singapore. I am Anjali Sharma, a student researcher at CIL. Today, we are fortunate to hear from 5 distinguished panelists, after which we will have a discussion where there will be an opportunity for the audience to ask questions through the chat box. I will now hand over the floor to our moderator for today, Daniel Yao, an adjunct senior research fellow and lead for cybersecurity law and governance at NUSCIL. Thank you.
Thank you, Anjali. Thank you, Anjali, for that introduction. And with apologies to all for the slight delay, we had some technical issues getting in the speakers, and we're trying to get all of them on board at the same time. So I do apologize and ask you for your patience in that regard. As that is ongoing, and my assistants in the background are getting in touch with the speakers who are still waiting to dial in on all the technicalities of that. Let us begin with a brief introduction, and I can start with the speakers who are already online. And we have indeed a lot of participants who have indicated interest in this. Probably a record. We have over 800 registrations for this event alone. The topic, a very topical issue of civilian hackers in state conflicts, legal status, rules of engagement, and obligations of states. Our discussions today, as the topic suggests, revolves around the subject of civilian hackers in state conflicts. In October 2023, the ICRC published 8 rules for civilian hackers operating in the context of an armed conflict and 4 obligations on states to restrain them. And this was precipitated by concerns over the emerging global trend of increasing civilian involvement in the conduct of cyber operations in armed conflicts, most predominantly in the Russian-Ukraine conflicts. Over the course of 2024, clear connections have been observed between state and non-state actors who are targeting critical infrastructure, using shared infrastructure and intelligence to attack operational technology and industrial control system targets. What has been the degree of observance and impact of these ICRC rules since its publication? And a lot of questions over the legal status of such groups. And some of you have actually posed those questions in advance at the time of registration. Is there a need and a scope for further evolution of international law as they relate to states' obligations vis-à-vis the activities of such civilian activists, or indeed the obligations for home states of this technology or social media companies whose platforms are actually being utilized by such activist groups? What about the duties and potential liabilities of technology and social media companies whose platforms are utilized by such activists? And what about the flip side, really, vis-a-vis the status, the rights of these private sector companies that actually hired to defend networks that are under attack by foreign cyber attackers? And with that, to discuss this and more, I'm delighted to welcome, in the order in which they will deliver their remarks, Dr. Tilman Rodenhauser, who's the legal advisor at the International Committee of the Red Cross, Dr. Samuel White, my colleague at the Center for International Law, who heads up or works on the peace and security work at the CIL, Associate Professor Len Xinyu from the China University of Political Science and Law, Dr. Giacomo Biggio, a lecturer in law at the University of Bristol, who's a visiting CIL scholar and from my alma mater as well at Bristol, so I'm very delighted to welcome him to this panel. And finally, Mr. Gaurav Kirti, who's the Adjunct Senior Fellow at the Center for Excellence for National Security at the RSIS School of International Studies at the Nanyang Technological University. I would invite you to review the very impressive bios, which are in the link above in the program. Right? Our speakers will reflect on the multifaceted perspectives on this very contemporary development in international law and international affairs, where we have a multitude of non-state actors engaging in activities that intersect with states and trigger profound questions on the rights, obligations, and accountability vis-a-vis these non-state actors. So on part one of this webinar, each panelist will deliver prepared remarks up to a maximum of 10 minutes each. And may I first then invite Tillman, legal advisor from ICRC, to start us off with some background to these ICRC rules. Thank you. Over to you, Tillman.
Well, thanks, Danielle. And first of all, really thank you for having me in this webinar. I remember how we discussed about it when we met in New York, and I'm very pleased, I'm very grateful for the invitation and to congratulate you for the distinguished group of scholars and experts that you have put together. It's a pleasure to be part of this event. Of course, I'm happy to give you to give the audience some background on the 8 rules for hackers that you just introduced. And maybe to start with a little bit of broader context, at the International Committee of the Red Cross, the ICRC, we have been monitoring the use of cyber operations by militaries, so by states, for over 2 decades, focusing on what are the capabilities and what's the potential human cost of their use. And many of the operations we are most worried about are actually conducted by states. But when we look at recent conflicts, especially last 3-4 years, we've seen a sharp increase in civilian, we call them civilian hackers. You can also call them hacktivists or hackers or any other name that makes sense. We've seen a sharp increase of these groups taking part in armed conflict. So at the time when we published the 8 rules, for instance, you had cyber threat intelligence reports saying that over 120 different groups take part in the Russia-Ukraine international armed conflict. And shortly after, when the war erupted between Israel and Hamas, you had even more groups being reported to take part in that conflict. And what worries us really, and what has triggered our work on this subject, is that in many cases, these groups do not go after military objectives. They don't attack the military. They go after civilian parts of societies, be they banks, private companies, civilian governments, e-services, but also pharmacies or hospitals. And myself, as an international lawyer, what bothered me in addition was that they disregard some of the most fundamental premises of international humanitarian law, in particular the principle of distinction, so not to attack civilians, but only to attack militaries. And in light of this development, we were thinking, how can we reach this very diverse group, very hard to identify, sitting around the world, literally from a hacker somewhere, maybe in Singapore, maybe in Geneva, to groups organized potentially sitting in territories that are affected by the conflict. And one of the angles of responses for us, not the only one, but one of the angles that we decided at the ICRC is to put out these 8 rules for hackers. What we did is we looked at the cyber operations we were observing. We mapped what are the IHL rules that are most relevant to those operations. And then we reflected how we can present them in a way that will hopefully resonate with these groups. And so the rules that you see in the 8 rules is the basic principle of distinction, not to attack civilians. Also the prohibition against indiscriminate attacks, so not to use tools that will spin out of control and affect civilians just as militaries. The obligation to take all feasible precautions, obligation not to attack hospitals and humanitarians. You can read all of them up. And what is important is in this development of such 8 rules, it wasn't just us sitting there doing it. We consulted with military operators. We consulted with cybersecurity operators. We consulted with white hat hackers. And we actually consulted and ran before publication those rules also by a hacker group to see that they are framed in a way that would hopefully resonate. But then what was the response? And I think that is significant also in the questions that you posed at the start. What was the response by hacker groups? When we published them, the BBC actually took them up and ran the groups, tested the group with some hacker groups. And the initial feedback, to be honest, was not great. Some asked, who is the Red Cross to tell us anything? And others said, if we follow those rules, most of our operations would be prohibited. And in the days after publication, some of our sister organizations at the Red Cross, their web services were attacked with a clear link to the rules. So it was really a very difficult initial reaction that we faced. But this, and that's fascinating, this changed within a day or two. And you had some of the most significant or well-known groups that that responded more positively to the rules. So after they initially dismissed the rules, the IT army of Ukraine shortly after said that they would make their best efforts to comply with these rules. And subsequently, they communicated that they will only support other hacker groups if these groups actually comply with what they call the Red Cross rules. And later on, they also claimed that they exercise restraint on some of the operations, not causing harm to civilians because of the Red Cross cyber warfare rules, as they called them. So that was positive. And similarly, maybe on the other side, the Russian group Killnet stated publicly a few days after publication that they agree with the terms of the rules. And what was significant is their leader translated them into Russian and shared them with this entire Telegram channel that coordinated that group. There was over 90,000 people that he shared the rules with and say he would like them to be followed. To be clear, we don't believe that even such statements mean that now these rules are respected, or that this diverse group of hacktivists, of civilian hackers, that they will now all comply with the laws of war. Of course, that would be overly optimistic. But I think the least that has been achieved is that today international humanitarian law has become part of the considerations by civilian hackers, and when experts and government look at civilian hackers, they do consider the legal angles of it and the limits that humanitarian law imposes also on their operations. Maybe the other important aspect is that we, alongside the 8 rules for hackers, we also reiterated 4 obligations of states. And this is really essential. None of these hackers sit in cyberspace. Sorry, that's stupid. None of them sit in cyberspace. They all sit in territory controlled by states. And many sit in a territory where you have functioning law enforcement. So it is primarily the obligation of states to ensure that civilian hackers on their territory respect national law, but also respect international law. And here, a state, of course, cannot prevent all hacking. It's practically very difficult, of course, but they can take certain steps that would bring us a long way towards respect for some of the most basic rules of international humanitarian law. The first one is, and that is something that the International Court of Justice has said, that states must not encourage violations of international humanitarian law. So states must also not encourage civilian hackers on their territory to conduct cyber operations in violations of international humanitarian law. They must also take steps, states must also take steps to prevent some of these violations. And the very least that states have signed up to under the Geneva Conventions is to make these rules known and to ask and to demand respect for them. And this many governments could easily do. And third, states have an obligation to prosecute war crimes and to suppress, to halt, to stop violations of IHL. This means they need a national legal framework and need to enforce that. And the very least that they cannot do is to turn a blind eye to these civilian hackers if they operate under their control. What has been the response by states to us recalling these obligations? I would say on the one hand, a lot of interest. States have seen the rules, states have taken knowledge of them. States have invited us to brief in the United Nations, in regional fora, with several governments bilaterally. But we also noted that for states, there is a larger security consideration at stake. It's not only or primarily the respect for humanitarian law, but there's also the thinking that what develops here is a phenomenon of a diverse group of hackers developing skills and also tools in the context of armed conflict, where states may consider them convenient for their purposes. But at the same time, I think also many government officials realize that you have there a group that may cause problems when wars end. So you have a group with skills and with tools that may not feel bound by peace agreements that will hopefully come for the many conflicts. And that subsequently, after the conflict, there will be a real worry also to the states in which they sit and that may have tolerated them. So I must say that in terms of concrete measures that have been taken to halt that phenomenon, there's certainly room for more. And this is also why I believe that today's webinar and today's discussion with such distinguished experts is so important.
Thank you very much, Tilman, for those setting the stage with those opening remarks as to the origins of the thinking, and more importantly, as we move forward, you raise a very important point. What do we do? How do we manage the potential complications that could arise at the end of the war? With that, I'll turn to Samuel, if I may, to address your comments on perhaps the more legal issues under public international law, what you consider to be the legal status of the civilian hacker groups and in the situation of armed conflicts. Over to you, Samuel.
Right. Well, look, I might start off with a compliment to the ICRC, being that I think that the principles are a fantastic step in a good way to start the conversation. I think we're stuck, unfortunately, with a system like IHL has always been, is that it's often a war behind. I was recently at a conference and the question in America, and the question was asked whether or not, if we were conducting operations now, if the law has changed since the 1980s, when Additional Protocol 1 came in. And a lot of the American military officers were of the opinion that it hadn't really for them. And being Australian, I disagree. We are bound by many principles now, such as the Safe Schools Declaration. I think Australia is in the process of ratifying the idea of the prohibiting explosive weapons in populated areas. And these are all initiatives by the ICRC. Right. But I would, with that done, I would also caution that I really dislike the term civilian hackers. I think it complicates the field. And I wanted to take a little bit of time to talk about that. So big picture international law is binary. There's two paradigms, peace and war, right? Armed conflict. Within armed conflict, it's not binary. There isn't this concept of combatant and non-combatant. You have civilians, you have combatants, prisoners of war. You also have medical and religious personnel, spies and mercenaries, journalists, hors de combat, protected people under occupied territory. These are all different legal statuses which either give you more or less protection for spies and for mercenaries. Nowhere in that do civilian hackers fit, right? There is no clear position. And it's kind of like talking about large-scale combat operations, which seems to be in vogue at the moment. I think it complicates the field. Civilians who are hacking is a question we have to ask case by case. So they're clearly not journalists. Journalists have a specific concept of being independent and they're not within the fight, right? So we can't turn around and say that civilians who are hacking or participating are somehow journalists. So then we asked, well, are they directly participating in hostilities? Now, that is a question that is case by case. I think for the most part, I would say yes. Like a lot of these civilians are directly participating in hostilities. There is obviously a fine line between just taking a photo of a battlefield and uploading it onto Instagram. There is no nexus there there's no directness to the hostilities. Again, as well, just going through open source intelligence, like many blogs do, Bellingcat, for example, is a good one. They're not participating. But there is a degree that we're quite clear individuals are participating. And I would say if you're providing intelligence that is leading to targeting lists, if you are conducting ransomware attacks that are shutting down ports, which I think happened within Belarus recently, like there are clear measures that in any other case and in any other domain, clearly that civilian would be participating in hostilities. And that has consequences. I don't think we're here to talk today about the temporal connection. How long are you DPHing as a civilian? But it means that you are targetable. And I don't think that the conversation has got there yet, because perhaps we are stuck on this concept of a civilian hacker or a hacktivist, when the law is quite clear in this area. Now, I think later on, we're going to talk about should the law change, and I'll be the first to say yes. I think we're hitting a point where the law needs an update at a very minimum, and I think the ICRC is doing great work with that sort of in the moment. But it's quite clear to me that civilians who are participating directly in hostilities are a valid target. If you are just providing open source intelligence, or if you are providing the software for Boeing back in America, we wouldn't say that you are a direct participant, right? So I do think it is quite open and shut on that front. One thing that I'm particularly interested in when we talk about this area, and I've written on it for the Articles of War with West Point, is actually interning civilian hackers. So the idea of internment under Geneva Convention 4 is something that in past large-scale combat operations, if that's what we are to call them, has occurred within the United States. It occurred within Australia. It occurred. The idea of someone who is viewed as a direct threat by the state and that absolutely must be interned is something that is valid and legal under the Geneva Conventions. There are a lot of protections. 63 articles in GC4 go towards the protections for an interned civilian for security purposes. But it's something that states and government agencies are starting to look at, because it is one of the ways in which we can control civilians who are hacking within a territory or who provide a security risk. So I thought I might put those ideas out there and I might reserve a little bit more of my time for questions at the end, if that's okay.
Thanks very much, Samuel, for that quick introduction. The flagging of the term civilian hackers, and indeed, I think that's an important one, because when we look at the term civilian hackers, who are we actually referring to? Are those who are helping to further the cause of the aggression, or are they those, for example, and one of our peers, Mr. Gaurav, will speak a little bit more to that later, those who are acting to defend, for instance. And so I think there are various shades that we certainly like to think about. Very interested in discussion later on the views of panelists on the question of updating the law. That's a very key question in this regard. And you have raised this question of interning as well. So let's have some time to break this down a little bit later. And I also invite the participants online, please use the Q&A function to raise your questions, some of which has already been addressed. The next speaker I had was actually a professor, Associate Professor Ling Xinyu from China University of Political Science and Law. I just need to double check with my colleagues whether he's online at the moment. If not, then I will perhaps move on to Giacomo, if you'd be so kind, to start off on your perspective using the Ukraine IT Army as a case study, and then I'll come back to
Yes,
Professor later.
Daniel, I'm online.
Oh, you're online. Perfect.
Yes.
Oh, thank you so much. I'm glad you were able to get on. I was a bit concerned about that. So may I pass the floor over to you then, Professor Ling Xinyu. There's a lot of interest in your perspective, speaking as a China-based academic and sharing your insights on this issue, and also a lot of questions and curiosity, if you can speak to the position of the Chinese government on this issue. Over to you, Xinyu.
Okay. Many thanks to be invited for this seminar, and I think it's really interesting. And also the cyber attack or cyber operation, whatever it will be called, it is my research interest. So I take some notes of the specific points. I think it is critical from the perspective of China, and generally speaking, I think the certain legal obligations for the cyber attacker, also cyber hackers, as well as the state obligations, and is okay. And I found many similarities with the existing customary international laws or existing treaty law rules for international humanitarian law. For example, it mentioned the protection for medical care systems or the protection for critical infrastructures, for example, the objects which contain dangerous forces, etc., etc. Generally speaking, I think that most of the Chinese scholars, as well as my government, will accept that in armed conflicts, those critical structures, those critical infrastructures, as well as the civilian objects and civilian population, shall be protected, even if it was under a cyber attack or cyber operation. But the question is, The interesting question, yes, Chinese scholars diverged very sharply on a critical issues. The issue is only the destruction or the deleting of the data, for example, the data which is used for public medical purposes, uh, uh, but without physical damage for any civilian objects in the real world, whether this kind of cyber operation would be counted as the attack in the sense of Article 49, in the sense of Article 49, paragraph 1 of the additional protocol 1. So because as it was widely accepted that Article 49, paragraph 1 was the denotation for what is attack. And what I checked from, have seen from the rules for the cyber hackers as well as for the state responsibility have a pivotal question and the precondition. So all the obligation should be presumed to exist. It must be established on the presumption that the cyber attack are tantamount to the attack in the sense of Article 49 too. But the Chinese scholars are divided into two groups. When I check the articles or essays, the majority will argue that if the cyber attack do not give rise to the physical damage of the civilian populations or the casualties of the civilians, and it would not be suffice to be tantamount to the phrase of attack in the sense by a show. But the other side was said, only by the attacking the debtors, it will suffice. So, up to now, I found that nobody could convince the rest of the scholars, and so that's why there was no clear position from the relevant authorities of the Chinese government. The relevant departments of the governments are, for example, MFAs, the Arms Control Departments, and also the PLAs, as well as the Ministry for Industrial and the Ministry for Industries, and they make no clear statements. That's that's the unfortunate point. But generally speaking, I think the applicability of the obligations and the rules for hackers as well as the state responsibilities is acceptable. And but also I have some concerns with some technical issues. The number one is what is the nature for those state responsibilities or state obligations? I think that the file mentioned a great deal about the duty of due diligence. Yeah, but it failed to mention what was the legal ground for such kind of duty. So what I guess it may have three origins under the framework of international law. The first one, it might be the result of the interpretation of Common Article 1 to the Geneva Conventions, 1949. So yes, I agree with that. And it might also have another origin. It might be, for example, the interpretation of the Carpal Channel Dictum, namely that the state should not knowingly allow its territory to be utilized for the purpose of violating the rights or interests of another state. We may presume that from some certain treaties, for example, the Hague Convention number 5, and as well as the Hague Convention 13 regarding the neutral obligations of the states. We may presume that it might probably have some connection with the neutral obligations. So what I'm not sure is I found no specific place for how the duty of due diligence comes from. So this is my first point. And the second one is, yes, I agree with Samuel that this file really make the situation a little bit, get more and more complicated issues. Since Samuel have mentioned the specific idea for the notion of direct participation in authorities. Yes, I agree with, generally speaking, I agree with that. Yeah, but the question is, do you think that the rules are really binding just between the hostile states? You know, for example, state A and state B who are in armed conflict, or do you think that the applicability and the binding force of those powers should be expanded to the civilians who are in the territory of a neutral states? So this is another point for my concern. I think it is not so clear. And thirdly, and for the geographical scope, it mentioned that under the territory of one state, that, and of course the states are under the obligation to prevent such a cyber attack if it is a violation of the ISO. Yes, I agree. But nowadays, the technical developments of their internet or cyber operation, I think, is very, very fast. So people have noticed that the technology of the space objects are widely utilized within Palestine or in Ukraine wars, and we have to take notice of the space objects which can provide the internet access are widely utilized. For it might be considered as a indispensable parts of the hostilities. So are the states under the obligation, if the states are under the or have the effective control of those space objects which can provide internet access, so are the states under the obligation to prevent and punish the relevance violation by ITO? It is not clear. And of course, personally speaking, I'm expecting that the states have to take the responsibility to broaden the scope. And lastly, it is also my concern that regarding the scope of the temporal scope for those obligations. For example, so when does the obligation of prevent the certain violations of IHO start? Generally speaking, so there was no clear answer. In many cases, in the cyber attack or hackers operation just function as once. Yeah, but generally speaking, so shall we rely on the points that the states have the actual knowledge of the cyber attack, or should we rely on the constructive knowledge of the states? It is also not so clear. So that I think that's also all my part of the concern. Thank you very much.
Thank you, Xingyu, for shedding a little bit of light on the debate that is ongoing now within the Chinese academic community, and also by extension, some sort of reflections and we could draw and conclusions, at least as to the view of the Chinese government on some of these issues that you have highlighted. I would certainly be very interested to hear thoughts of the other panelists on what you have articulated. It's quite illuminating. And you spent some time talking about due diligence, which is a broader question, of course, rather than specific to the issue of civilian hackers and IHL. But certainly there are parallels, because we do and expand on the duties and the current discussion on due diligence, and how does it further, by extension, further apply to this group of civilian hackers, which are traditionally not under the direct control of any government authority. With that, I think, Giacomo, can I kindly bring you in, Giacomo, to give us your thoughts on the case study, looking at the Ukraine and the IT army, when we can see how some of those principles that Tillman, Samuel, and Xingyu has talked about, and how do you see that applying and finding form in this case study? Over to you, Giacomo, and I believe you have slides which you can share on your end.
Yes, you can share my slides. Thank you so much, Danielle, for introducing me, and thanks to the speakers for their very interesting presentations. So,
are you bringing your slides, Giacomo?
yes.
I don't see them yet. Just wait a while now. Make sure that you're spotlighted as well.
Yes. I think I was under the impression that you would have shared the slides because I
Oh,
can
if you want, we
see.
can do that.
Okay. All right. Yes. I can. Fantastic. All right. Can you see
we got
the
it.
slides?
Yes.
Perfect. So again, thanks again, Danielle, for introducing me. In my very brief presentation, I will look specifically at the case of the IT Army of Ukraine, because I think it connects very well with some of the issues that we've been discussing so far. The principle of distinction between civilian and combatants. What's the status of the IT Army? Are they civilians? Are they combatants? What about the operations that they've been carrying out? Are they, to what extent they're regulated by international humanitarian law? Do they amount to an act of direct participation in hostility? And what about Ukraine's legal responsibility in relation to the IT Army, to the existence and the operation of the IT Army? And specifically in this presentation, I will focus on just two of these issues. Ukraine's responsibilities under Common Article 1 to the Geneva Convention, and Ukraine's duty to warn members of the IT Army about the consequences of joining the IT Army, as doing so may, in certain circumstances, make them liable of being targeted as direct participants in hostilities. What is the IT Army of Ukraine? We can describe it as an organized hacker collective controlled to some extent by the Ukrainian government and the Ukrainian SBU. It was created soon after the Russian invasion of Ukraine, when in February 26, 2022, the Ukrainian Minister of Digital Transformation, Mikhailo Fedorov, announced its creation. And soon after, it amassed more than 300,000 individual members. These numbers now have almost halved 3 years into the war. But the IT Army has been engaged in a number of cyber defensive operations against Russia, cyber offensive operation against Russian military targets, governmental targets, such as Roscosmos, the Russian space agency, Russian Railway, RZD.
Hi, Giacomo, I'm so sorry to interrupt. I think your presentation is not being seen. I'll just be the one to share it.
Okay, so you're still in the first slide, I assume.
Yeah, can you stop your sharing and then I'll
All
share
right.
it for you.
Giacomo, I think your camera is not on as well. So if you could do that, then we can also.
My camera
see
is on.
Okay, all right.
It's blacked out right
functioning here.
Yeah, we don't see you either.
Okay, and you see the first slide of my presentation.
No, not either. So I'll be the one to share.
All right.
If possible.
Perfect.
Yeah. Can everyone see it now?
Yes, we are now in slide. If you just call out the slide number, Ryla, so Giacomo is also
slide
able
3.
to see this.
Yes.
Perfect.
Yeah, we are in slide 3.
Okay, so apologies for the inconvenience. So, as I was saying, the IT Army has carried out a number of cyber operations against Russian governmental military targets, as well as private targets such as the Yandex Taxi company or Russian banks as well. So, to what extent these cyber operations engender legal responsibility on Ukraine? Well, the answer is we need to look into Common Article 1 of the Geneva Convention, and I'm moving into slide 4. So the next slide. And according to Common Article 1, the parties to the conflict undertakes to respect and ensure respect for the convention in all circumstances. The duty to ensure respect as a positive obligation of conduct requires each state party to take all necessary measures to achieve the desired result of ensuring respect for international humanitarian law, which would include disseminating the convention, preventing and suppressing breaches, prosecuting the perpetrators, and not encouraging violations of international humanitarian law. And Common Article 1, moreover, incorporates a duty of due diligence, right, which will have to be evaluated on a number of contextual factors, such as the foreseeability of the violation and the state's knowledge thereof, the gravity of the breach, the means reasonably available to the state, and importantly, in relation to the IT Army, the degree of influence that the state exercises over its own agents and on private persons. And this is a very important point, I believe, because the tighter the degree of control that Ukraine exercises over the IT Army, the tighter the scope of the due diligence obligation. And Common Article 1, the duty to ensure respect, includes actions committed by state organs and actions attributable to the state under the law of state responsibility. I think that with regards to the IT Army and Ukraine is particularly relevant Article 8 of the law of state responsibility, according to which the conduct of a person or a group of persons shall be considered as an act of the state under international law if the person or group of persons is in fact acting on the instructions or under the direction or control of the state in carrying out the conduct. And there's been evidence that members of the IT Army have been receiving instructions on what cyber tools to use, what are their targets via Telegram. And so the criterion of instruction would be satisfied. And surprisingly so, even the criterion of direction and control, which is usually a very high threshold, because what is required is that the state must control all phases of an operation that amounts to a violation of international law. It's beginning, execution, and end. But we know from insider information, a former member of the IT Army, that the IT Army is comprised at least of two tiers. At the upper echelon, there are 25 to 30 generals from the Ukrainian government and the Ukrainian SBU, which manually select IT specialists, so-called colonels, to carry out cyber operations. So there is no doubt that Ukraine is bound to a duty to ensure that the IT Army respects international humanitarian law. But what is the main issue is that the practical effectiveness of this obligation is adversely affected by the disagreement on how key IHL concept should be interpreted. Namely, for example, the notion of attack. What is an attack under international humanitarian law? This is not clear. There are mainly two competing interpretations. One that only considers attack cyber operations that cause kinetic effects in the form of death or injury to individuals, whereas the interpretation that is endorsed by the ICRC and by a growing number of states is that cyber operations that disrupt the functionality of an object without causing physical damage would qualify an attack, or even cyber operation that will destroy or delete digital data. But this is still an open question. And I found it interesting that, for example, Ukraine has publicly boasted online to have infiltrated the tax system of the Russian citizens. That tells a lot about Ukraine's stance on what cyber operations should be considered as attacks and regulated by international humanitarian law. And lastly, looking at the very last slide, I would like to briefly focus on Ukraine's obligation under Article 58 of Additional Protocol 1, which provides an obligation on parties to the conflict to take necessary precaution to protect the civilian population, individual civilian and civilian objects under their control against the danger resulting from military operations. These provision can be read to imply a duty to warn civilians that by joining the IT Army, they may committing acts amounting to direct participation in hostilities. So this would entail loss of protection from attack for acts satisfying the three cumulative requirements of threshold of harm, direct causation, and belligerent nexus. So, for example, if the IT army have targeted Russian railways in an attempt to adversely affect Russian military capacity by disrupting their logistics, that would possibly qualify as an act of direct participation in hostilities. It's less clear, however, if targeting Russian banks, maintaining passive cyber defense to help Ukraine against Russia's cyber operations would qualify as an act of direct participation in hostilities. And maybe this is a question that we can discuss later. So thank you again for your time and consideration, and apologies for the technical issues.
Thank you, Giacomo, for a very clear presentation, applying what has been discussed by previous speakers to the very specific issue of the IT army of Ukraine, and some very useful insider information on the dual track, which I found quite fascinating. In fact, there were questions from the participants who have registered earlier, asking precisely about this question of attribution, responsibility, and direct participation in hostilities, which you have addressed in your presentation very well, and certainly looking for a much deeper discussion on that issue later. And finally, last but certainly not least, I'm delighted to bring Gaurav Kirti from the Center of Excellence for National Security, who will be sharing with us his perspective on these issues. And I've asked him in particular to talk about the perspective in relation to technology and media companies, and what kind of policy considerations, what kind of operation considerations, and what are the kind of dilemmas they face and the issues they face that as policy decision makers, as public international lawyers, we need to be aware of, and fit that into the debate as we go along. So over to you, Gaurav.
Thank you so much, Danielle. And wonderful to round out such a fantastic set of sharing from all of the previous speakers. Maybe a little bit more context on my background to help people understand the points that I'm about to make. I started off with about 25 years in the military, where cybersecurity was one of the functions that I did. I moved on to do some time in the government. So I was with the Cybersecurity Agency of Singapore. And now I'm in the private sector. So I am an adjunct at RSIS. But my primary role is in the private sector, where I work in a cybersecurity company, which does exactly all of the things that we've been describing on the defensive side. But it creates opportunities for me to understand the complications and the complexities from a corporate perspective, as well as the government perspective. And I'll share a little bit more about that. The conversation about cyber activities and cyber actors is complicated and quite complex. Let me start by unpacking the who first. Who are these people? It is, as many of the previous speakers have shared, it is not a monolithic entity. There are many different shades of gray of cyber attackers, and sometimes the Venn diagrams overlap. I start by sharing about state-sponsored attackers. It's the clearest case. This is their day job. We have seen cases where a cyber attack was underway, and interestingly enough, the cyber attack was conducted only during office hours of that particular country, where those individuals would take lunch breaks and would take holidays during public holidays. That's not typical cyber attacker behavior. It means that it is their day job. They are getting a daily or monthly salary from an organization to do this. That's the pattern of behavior we see for cyber attackers who are pure state-sponsored. We then come to those who are state-endorsed. And this is a slightly murkier area. They are sometimes mercenaries, there's sometimes affiliates, there's sometimes organizations that are loosely connected to the government or funded by the government in some way. We move on to then the criminal actors. The criminal actors are very clear-cut. They're financially motivated. They want to basically create some sort of cyber disturbance or nuisance in order to get a little bit of money out of it. We come to hacktivism, which is what our previous speaker shared about the Ukraine IT army. Hacktivists are politically motivated. They have an agenda. They have a cause. Sometimes they are funded by the government. Sometimes they are not. Sometimes they are directed by the government. Sometimes they are not. The last group, which people don't really think about, are the defenders. Now, they're not quite civilian hackers, but if you think about the actions that a defender may take in response to a cyber attack on a company that they've been hired to protect, sometimes it involves stopping the attacking infrastructure. If your organization is under a severe attack from a set of infrastructure that is overseas, you can, without technical means, you can use legal, operational means, sometimes even calling the cloud service provider of the offending system to ensure that they stop that particular server from taking the actions against your company. But in the course of those defensive actions, which you've been hired to do, you are taking on actions against another person's infrastructure. It may not be technical, it could be operational, policy, legal, for whatever reason. So they are also involved in the space of taking deliberate action against somebody else's infrastructure in somebody else's country. Now, making this situation actually complex is the fact that at the point of the conflict, nobody has any clarity at all as to which one of these groups is attacking you. You don't know if this attack came from a state-sponsored attacker, a state-endorsed actor, a criminal group, a hacktivist, or a white hat hacker that went rogue and is trying to find a vulnerability for disclosure. You don't know. And every day when we sit in the ops center and we monitor the activities happening, our challenge is we have to respond to everything, but we don't know who it's coming from or where it's coming from. So the dilemmas and the legal conversations we have about attribution and the responsibilities of state to not condone or not allow such behavior to happen through their state, those are fantastic conversations to have 3 months later. But in the heat of the actual attack, there is that opacity to the actions and the actors, which creates what we call a digital fog of war. The defenders are on guard 24/7 against a set of actors who we don't quite know who they are. Even if we do know who they are, most are not very clearly defined. When does the state sponsorship of an actor become, or state sponsorship of a criminal group become a state-sponsored actor? Knowing that the actor is an APT from an advanced persistent threat from one country is not quite useful anymore because of the way in which the organizations form in the cyber world, especially the attacker world. There are a lot of blurred lines. If you think about people, processes, and technology as 3 distinct areas or domains, the people themselves sometimes double hat or triple hat. The person who is an ideologically motivated hacktivist could also be working for a criminal group, could also be working for a state-sponsored attacker, and could also have a day job in a company like mine. So the people themselves have that kind of fluidity to their identity, which is a problem. The processes, the technology that they use, the processes they use are all linked. In order to take an attack on any particular infrastructure, you need a series of capabilities interlinked to effect that. Gone are the days where a single organization has all of the necessary technical and operational capabilities all by itself to attack a target. That no longer is the case, and that's no longer the default. Even the most sophisticated state-sponsored attackers use tools that they find on the dark web, acquire tools from other actors, from other developers, and use infrastructure from other actors and other developers. So you've got this huge blurring of people, processes, and technologies where the supply chain of the bad guys makes it impossible to determine who actually is a civilian hacker that's within any of the definitions we spoke about earlier. Is the person who developed the malware also part of a civilian hacker group, even if they no longer are part of the operational deployment of that malware? Is the person who hosts the infrastructure, what we call bulletproof hosts, are they also part of the infrastructure or the attack chain? So all of that creates huge problems. And I'll be the first one to admit that none of the corporates that I work with or the corporate that I work in currently have any form of governance that thinks about this particular dilemma. This is not something that we are designed to think about. I'll share one specific example and some of the concerns that we have with hacktivism, for example. We hire white hat hackers, and we provide a service to companies who want to understand their vulnerabilities by red teaming or by doing penetration testing. It's a normal service many commercial companies provide it. But we need to make sure that the people that we hire never, ever participate in the Ukraine IT army, because that creates huge dilemmas for me. At some point in the Ukraine-Russia conflict, Ukraine called upon people who supported it and its own citizens who were working in other companies to use their access to deny Russia's advance. Now, that's hugely problematic. If I have to worry about the political leanings of my staff when I give them access to a customer's network, let's say I have a staff ABC, and he has access to a company, a bank, for example. Is he going to use that just to do the service that the bank hired him to do, the penetration testing? Or will he, because he supports Ukraine, use that access to then go there and delete the bank accounts of Russians? I don't want to take that risk. But thinking about the HR dilemmas for my staff in a corporate because of hacktivism, that's not a governance process we are equipped to deal with. So the risks of hacktivism, for example, create downstream knock-on concerns in the corporate world and the government world that are really problematic for us to think about. And it may not be as huge as the legal dilemmas, but on a day-to-day operational basis, they do create some dilemmas for us. And so we see all of these cracks and gaps emerging because of the blurring of the lines. And I'm happy to get into a conversation of what this means operationally in terms of the day-to-day work of the cybersecurity industry as well. But thanks so much.
Thanks, Gaurav. Perfect. It was a perfect round off to setting the scene for. We've had a very important and, of course, interesting legal discussion. But none of this can operate in vacuum without pegging it together with the very real operational concerns. And now, of course, the dilemma, as you put it, from the corporate's perspective, and I would really invite our 4 other panelists to really delve into this in their comments. The floor is open for questions to be posed. Please use the chat box. We've taken note of the questions that we posed in advance. Some of them have already been addressed by our speakers, but let's just start with some of the questions we want to delve with. And the first, of course, is we're starting from the beginning. We started with the ICRC rules, and I'd like to turn to Tillman. I mean, it's been more than a year since, right? What is the impact? How has it developed? Is there a future evolution for that process? And feel free to also comment on what the other speakers have spoken on.
Thanks, Danielle. And that is, of course, the big question. But before I get to it, let me just say really insightful comments from all other experts. It was excellent to listen to you and to hear the different perspectives. On your question is, of course, related to what others raised on, do we need new rules? Or what's the possible evolution of these 8 rules? And maybe to address it, let me go back to the question, what's the status of these 8 rules? Because sometimes they are presented as the ICSC setting out rules for engagement for hackers, or ICSC presenting a new Geneva Convention for hackers, as if we were writing new law. And it's very important, I think, and also not always understood by experts, that of course we don't write new law. None of the rules that we present, all of the rules that we present have a firm basis in existing either treaty or customary international law. And so none of that is new. None of that is some form of soft law. They're all existing legal obligations grounded in the existing law of armed conflict that applies, including to cyber operations. We need to make sure they're understood and they're respected. And I guess to be understood, the very first step, and we have that, of course, in cyberspace, but at the ICSC also in the physical space, where we work with traditional non-state armed group, rebel groups. The first step is always to understand the rules, to learn about them, to understand them. And I would say that with most groups, we are still in that stage where we need to somewhat socialize and gather respect for the fact that there are rules that apply in war. And here, as I said before, a key role, of course, you can turn to humanitarian actors or maybe academics and other experts, but the key role is for states. And what colleagues discussed about the due diligence obligation to ensure respect, yes, of course, that's a big part of it. And we can discuss some angles of due diligence, but I would say the very basis is not disputed. Because under the Geneva Convention, states have taken upon themselves to disseminate knowledge of humanitarian law. So need to make that. That's written in the conventions they've signed. And they need to stop IHL violations, and they need to prosecute those that amount to war crimes. And actually, at the moment, the International Criminal Court is even looking at how the Office of the Prosecutor would look at cyber-related war crimes. So there are avenues that need to be pursued. And maybe let me get into one point that was raised by several of the expert speakers about the notion of attack. That's really crucial for some cyber operations and for some of the 8 rules. When you actually look at the 8 rules, I looked at it in depth, it's relevant for 4 of them, where the IHL rules depend on whether an operation amounts to an attack or not. For instance, humanitarian and medical facilities, any cyber operations against them that have harmful effects are prohibited. It doesn't need to be an attack. So the notion of attack is only relevant for part of them. And yes, it's true among Chinese academics and among states and other government and other experts, there are disputes of what amounts to an attack. And I think what's really important is that there's more and more understandings and positions of states that it's not only cyber operations that cause physical destruction, which are only, I would say, a tiny minority would amount to an attack, but there are many more that cause disruption. Costa Rica, for instance, has said ransomware that cripples our government systems. Of course, we consider that an attack under IHL, and so the attacker will have to respect principle of distinction, proportionality, precautions. So the tendency that we see over the last 5 years, notably among states, is a larger notion of attack or more cyber-adapted notion of attack, and that's really important. But even if we came to the view, or even if governments take the view that some of these operations are not attacks under IHL, but only operations, you still have rules that apply. You still have an obligation of constant care not to harm civilian objects and civilian populations. I can't see how targeting civilians would be reconcilable with an obligation to take constant care. So it's really important that we discuss some of the depth and some of the really intriguing operational issues that Gaurav raised, but we also need to be careful not to raise too many questions on some of the very fundamental principles, not to suggest that they somewhat wouldn't be applicable or wouldn't need to be respected.
Thank you, Chairman, for starting our conversation on that future evolution and the areas which you think perhaps needs some further unpacking. And I'll turn now with that precise question and task to Samuel and to Sydney. And maybe Samuel, you could start first. I mean, having heard all that, how do you think international law should evolve to clarify the questions of state responsibility, whether in preventing or in tacitly supporting such groups, and a certain number of gray areas as well, relating to civilian versus combatant status. So I'll put that over to you to unpack some of these questions. And after that, Xingyu, if I could invite you to do the same. Thank you.
Okay. I think in answering this, you can sort of say there's two, it's a sliding doors moment, right? You can sort of say, in this perfect world where we can create new law, this is what I would have. And then that you can also say, we're not going to do any legal change, like any legal frameworks, we work within what we got. So I might start with the first, which is if I could change and create whatever law I wanted, I would use the Outer Space Treaty as a model. So Outer Space Treaty is a bit of a weird one for those that aren't often familiar with it, but it was created in 1967. It's off the top of my head, but I think it's right, 1967. And middle of the Cold War, still a very good example of cooperation. And Articles 6 and Article 7 are the really important bits there. So what it creates is a framework for state responsibility if it's a government or a non-government entity that launches something into space. So to give a theoretical, Australia is the launching country. Its territory, something goes off. A Singaporean company using multiple different nations worth of kit, but a Singaporean company launches a satellite from Australia. Article 6, Australia is responsible. Article 7, if something crashes, Australia is responsible. Now, that is a very clear and clean model, I think, for all of this drama that we're talking about with civilian hackers, right? Because what we're arguing about is, can we attribute, it's so opaque, how can we possibly know what's going on? There's different systems. Now, I understand that launching a satellite into the outer space is a pretty clear who's done it and where it's come from. Very different to cyberspace. But if I could wave my magic wand and create a framework, it would be something along the lines of, if it's emanating from your physical territory, the state is responsible. And you could build into that some sort of level of, unless you've taken steps to prevent it, but to be able to put in hard law this due diligence obligation, because I think a lot of states really are debating the extent to which they are required under due diligence obligations. That then takes me to the second bit, which is if we don't change the law. I've been in enough rooms with ICRC personnel that if we start talking about a digital Geneva Convention, there are heart attacks that occur. I think we've missed a point in human history, perhaps, where we can have such a universal uptake in a additional protocol 4 or something similar. I think we are finding there are multilateral treaties that are slowly developing, even if it's not within cyber warfare or armed conflict, if it's like the Budapest Convention for Cybercrime, we're starting to see slowly that the law is developing. But I also think we're starting to realize that everything is so interconnected that it's not worth shutting down entire systems. So I know, 25 years ago, when people started writing about the risks of cyberspace and the ubiquity of cyberspace, there were fears that there would be, a global blackout or that entire energy systems would be knocked out because of hacks. And I don't think we've seen it at the same level as what was feared. People are naturally pulling back from that total warfare perspective online. I think within cyberspace, what we're actually seeing, and we can see it in the comments from different states, the United Kingdom is probably the best example, is the United Kingdom has announced that sovereignty is a principle, not a rule. Now, that is a very interesting approach. You compare that, say, to the French or Costa Rica, which has made very clear that if you touch their system, they consider it an attack. We're seeing states are naturally, I think, falling into a rhythm of a little bit of competition is occurring in cyberspace, but we're not having the full-blown attacks that we've seen or that were hypothesized in the past. So I think, in short, states and people will tend to step back from the total warfare that everyone is concerned about. It's actually a lot more economic. I think maybe something we haven't really talked about in depth here this evening is the economic drivers behind ransomware attacks, and these economic drivers behind what are developing the tactics, techniques, and procedures in cyberspace that are then being co-opted within warfare. But the idea of ransomware, I think you're much more likely to have a corporation struck by ransomware and that ransom is paid than perhaps all the data is destroyed for some sort of hacktivist seeking to support a state. Yeah.
Thanks very much, Samuel. On a rather optimistic note that you've brought us to, not all doom and gloom in as far as cyber warfare is concerned, but I suspect some in the audience and even among the panelists may not entirely agree with you, but I see Gaurav nodding already, so I will definitely be looking to you. But it's interesting that you do this sort of almost strict liability bifurcation as an analogy for the liabilities, and of course it provides clarity. But again, I think I would love to hear Gaurav's response and view on that in terms of how do you, in a literal, practical sense, put on the lens in this strict liability approach. How does it help the corporate companies? Xinyu, would you like to? Can I invite you to address this last question? Thank you.
Okay. Yes, many points I think are. It really seems so confusing for me. I think the number one point, Article 8 of the Chapter Articles on State Responsibility. So in a lot of cases, people mention that you may rely on the direction or the control test that a state are going to be responsible for some individuals or a plurality of individuals and yeah, but the really question, I have to say that International Court of Justice really make the threshold extremely high. It's extremely high. So according to the effective control test, you must find out the evidence to show that there was a specific instructions or order from the state to a person, and only under such occasions that the attributability are established. And really, since it's really high threshold, so there was a debate and in the context of certain cases of ICTYs and the Yugoslav tribunal suggested that the overall control test will be okay. But unfortunately, in some recent cases, and we may just assume they're from the Bosnia-Herzegovina genocide case, and also the Croatia and Serbia genocide case, and in so many cases, and ICJ still relies on the effective control test. So personally, if we transpose from the physical world to the cyber domain or cyberspace, we may find the big military power state. The big military powers, it was almost impossible for the international community to hold any states responsible for that if we rely on Article 8, because to secure the evidence for the specific instruction are extremely hard. So my personal understanding, I'm always on the side of ICTY. I think only the overall control test will suffice to secure the state responsibility. So number one, and number two, according to my understanding, there might be some gap between the state responsibilities on one side and on the other side of the coin was the individual responsibilities. For example, so for what was mentioned by the files, the attacking of nuclear power plants. Yeah, of course, it was considered a serious violation of international humanitarian law, but it was excluded from Article 8 of the Rome Statute. So in terms of the individual responsibility for crimes, so it was absent. It was absent. So what I'm expecting that the academic sectors they maybe contribute a little bit to fill this gap, because as I understand it, in terms of the individual responsibilities and in terms of the state's responsibility, the attacking for a nuclear power plant should be both considered as a serious violations and should be criminalized. Yeah, but according to the failure of the negotiations of the Rome Statute, it was absent in the circle of international criminal laws. And my number three observations, I think that we might see that in terms of the responsibility for IHO, it may develop a little bit faster than the international criminal law. Because we have no idea whether, for example, the attack on the data or databases should be identified as a violation of IHO. But nowadays we can apply a technique which are called evolutionary interpretation under the general framework of VCLT. And state parties may find ways to broaden the interpretation to cover as broad as possible. And then under such an approach, we may find that the attack may be broadened. But what I have to say, the attention on in the sense of international criminal laws, Article 22 of the Rome Statute, the prohibition of analogy. Everything must be strictly constructed. So that's for my personal understanding, I think that maybe the Rome Statute close the door for broadening the interpretation. So this might create a huge gap. Yes, thank you so much.
Thanks very much, Shingi. Thanks, Shingi, for pointing to a point which I wonder whether it's time to get into, right? Because this relates to questions relating to international criminal law, but also your more vanilla envelope type of criminal responsibility, because there are questions relating to, does the UN Cybercrime Convention, can that come into plug certain gaps as well? Not everything necessarily needs to be dealt with. And that goes to your point about individual responsibility vis-a-vis state responsibility as well. Giacomo, I want to turn to you because I think, ties in very well with Gaura's comments on technology companies. And you have written very interesting articles on the international law, how should it impose specific obligations on these companies and the home states of these companies? What should this address? Could you perhaps in the maybe 5 minutes or so, or less than 5 minutes, bring us through those?
Yes. So
I'm sorry,
yeah,
we can't see you for some reason,
yes,
unfortunately.
unfortunately, my camera decided to stop working at
Okay.
the wrong time because everything's on, but I also see a black screen on my end.
Okay.
So
No
that's what we have to work with. So in the article in my recent article, I looked at potential responsibilities of Facebook and Meta in inciting violence in Myanmar. So it will be really the use of social media to incite the commission of acts of physical violence. And in that case, the answer could be to a certain extent that maybe individuals might be held complicit in facilitating those violations of international humanitarian law. But I think that the cyber dimension adds a further layer of complexity. What kind of violation of international law and international humanitarian law through cyber means are we talking about? If, let's say, Telegram allows members of the IT army to join within Telegram and to coordinate their operations there. It all boils down again to issues of interpretations. Whatever cyber operations they are performing, to what extent these cyber operations are regulated by international humanitarian law. Maybe they are regulated just by a duty of constant care. Maybe they are actually attacks. If we adopt a broader interpretation, but again, even if we adopt a broader interpretation that encompasses non-kinetic effect, which is, I think, now the majoritarian position of most states who have expressed their national views, those states have not said a single word on how are we meant to apply, let's say, the principle of proportionality to non-kinetic effects, to what would be disruption of civilian services or economic harm. And there is a big debate among states over whether or not the principle of proportionality also includes economic harms. And the principle of proportionality is now relevant for the prohibition of disproportionate attacks. And so we can only allocate responsibilities to tech and social media companies if we clarify the meaning of certain key terms that are needed to determine if a violation of international humanitarian law has been committed in the first place. Well, clearly, for example, if the IT army, as they did, use Telegram to organize a website defacement of the Wagner Group web page, as they did, and then they post dead pictures of members of Wagner online, that could, regardless of whether or not it's an attack, constitute a violation of international humanitarian law. Arguably would be an outrage upon personal dignity. Same with attack that delete or alter medical data. And in that case, we can, I think, construe a duty of due diligence on social media companies, either through national legislations or through the UN guiding principles on business and human rights. And on the end of national legislation, it's really easy, in my opinion, to make a direct link with the responsibilities of states under Common Article 1. The duty to ensure respect also includes, as all necessary measures should be taken, also includes the creation of an accurate legal apparatus that would ensure that social media companies actively monitor certain types of content. So these are my 2 cents on these complex pictures of responsibilities, where and to what extent they should be allocated, and even the problems that precedes the allocation of responsibility.
Thanks, Yokomo. I think that topic itself deserves an entire webinar just on its own to unpack. Let me turn to Gaurav. I think he's itching to come back on the points I have discussed, and I've also see if you could have any words more generally on whether you see a shift in how states perceive and engage with non-traditional actors in conflict, and what is your sense of the impact on the broader international sort of geopolitical landscape. But over to you, Gaurav, perhaps in less than 5 minutes. Thank you.
And no worries, I'll try and be concise. I think, again, fascinating conversation. And I love that we're trying to understand and unpack some of the conceptual and legal issues while dealing with the practical realities. Again, using my perspective, I'm going to bring us back down to the practical realities of some of these issues. How do states engage with non-traditional actors? Particularly when we're talking about the use of civilian hackers, unfortunately, the bad news is they've started engaging them more. Using civilian hackers becomes non-attributable, becomes very difficult for states to then determine that this particular bad person, this malicious actor, was doing actions from your country. You can disavow that it was supported or sponsored by you. This gives rise to a huge amount of gray zone and hybrid warfare because the options are just numerous now. You can contract a cyber criminal group to ransomware a company in a country that you don't want to, or you want to pressure. You can outsource some parts of cyber criminal activity or even cyber malicious activity in general, not just to the Ukraine IT army, but to any number of actors in the dark web. So the options for gray zone operations becomes much broader. I love the idea and the concept of having strict liability, but here's where I will be a little bit of a wet blanket. It's not possible. And I'll explain why. Firstly, it's not possible to determine what activities are being taken in one's country and not in one's country. The internet isn't designed by geography. The architecture of the internet is not respectful of people's borders. It's respectful of a set of pipes and a set of protocols which don't always abide by how we've drawn our Westphalian border system. The big tech organizations themselves are not designed to respect borders. If I were to ask, for Telegram in that case, who has full jurisdiction over Telegram's infrastructure? Aside from Telegram, none of the countries do. If I were to ask an even bigger question, who has jurisdiction over Microsoft? Again, it's incredibly unclear that any state is able to command Microsoft to do anything. Within the confines of your own criminal set of laws, you can ask them to support certain investigations. But even then, it becomes incredibly complex for them to determine that it's Microsoft's responsibility to make sure that every user of Microsoft secures their cloud account in such a way that no malicious actor can ever abuse it to attack another country. And adding even more complexity to this conversation is each time any of us signs up for any account, and I'm not singling out Microsoft, but any account, you go through 355 pages of terms and conditions, which we all scroll to the bottom of and click agree. And in those terms and conditions, I guarantee you, big tech has found a way out of the liability of their systems being abused to attack other countries. So while in concept, I applaud the idea of strict liability, in practice, the technology companies that are the conduit for all of the actions have positioned themselves out of strict liability. The individual actors themselves are impossible to determine, which makes that strict liability very difficult. And the opacity of all of the actions that are being taken are very different from a satellite taking off from Australia. A rocket takes off, there's a physical presence, there's people there, there's an action that can be seen, and all of that is traceable. In the internet, it's all untraceable, and that becomes incredibly complex for us to find. I'll give one kind of closing story to just illustrate how difficult strict liability is. A couple of months ago, a software called CrowdStrike crashed and took out hundreds of thousands of computers. Even in a case where we know exactly which company did it, and we know exactly the damage that it caused, applying strict liability to them is incredibly difficult because most of the customers signed that 300-page terms and conditions. And so that becomes very complex for us to deal with. So I think that we're moving in the right direction by clarifying the laws around criminal behavior, but I think we have a long way to go before we are fully clear how to deal with civilian hackers in combat situations, on cyber situations. Thanks so much.
Thanks
and I
very
hate to
much,
end on a down note, Danielle. I wish I had a more optimistic ending.
Perhaps I can look to the other panelists to be optimistic. I think we have, because we started a little late, I'm going to leave 1 or 2 minutes for each panelist to come back with the final, perhaps 1 minute comment. And I just wanted to take this opportunity to also flag some questions which have not been addressed. And if you wish to address those in your closing comments, that's fine as well. We had a number of questions to attribution, which I think has been very well covered. But this question of criminal liability, 1 or 2 have asked questions about drawing reference to criminal laws, drawing reference to the relevance of the UN Cyber Convention. Perhaps that is something that panelists would like to address. There's a very specific question of whether you're aware of any cases where states have actually taken steps to hold civilian actors accountable. That's perhaps a question that could be addressed on a more elaborate level as well. And finally, perhaps a philosophical question. Does the law realistically have any chance of catching up? And that is a question that has also been posed, including a pragmatic question about education of civilian hackers around the rules of IHL. And one question more in the realm of James Bond, right? What if the civilian hackers become double agents and end up working for the adversary? And how do we treat those actors? So take your pick. One fine sentence for
Hi,
each
everyone.
final
Good
panelist.
afternoon. Thanks for taking the time to attend.
Okay. Would you like to start, Giacomo, with your final less than 1 minute comment?
Okay. Maybe I'll just wait for a few more minutes for the rest of our colleagues to stream in. I'm waiting for Rahul on my side to join as well. So I'll just give it a couple of minutes. There you are, Rahul. Hello.
Danielle, sorry, you're muted.
Sorry, I'm hearing a third conversation going on, and I'm not sure
Yes,
somebody
me
seems to have
too.
crashed.
And
Yeah.
I'm sorry, I think it was a participant. I just muted them.
All right. Okay.
Apologies.
Thank you. Yes, I do apologize. Giacomo, would you like to start us off? A quick 1 minute
yes,
for each.
if you could repeat your the two questions, because there's been a lot of
Sure, no problem. No, I mean, I think you open question. You can comment on anything that you want, but I was just sharing on some of the questions that have been raised. One of which is, as I said, the final question that I posed was a more philosophical question. Will the law realistically have any chance of catching up? And how do you educate civilian hackers about IHL?
Does the law have any chance of catching up? I would say it depends. What do we mean by catching up? Because we're entering an era in which what is promised is a technology, which is AI, that can really do anything, that can compute the world and predict everything. And if everything is computable and predictable, then that puts the law, I wouldn't say at a strategic advantage, but at least at a better, in a better situation with regards to technological development. That could solve questions of technical attribution, for example. That could have an impact on due diligence obligations. That could potentially solve question about tracing where a cyber attack comes. That could have also an impact on the concept of direct participation in hostilities. In my opinion, is also interesting in relation to the foreseeability of harms that can be created or caused by a cyber operation. I was looking into the hacking of the Viasat satellite by allegedly the Russian armed forces soon after Russia invaded Ukraine, and there had been some cybersecurity experts that have, by the use of technology, theorized how the attack took place, and it's by simulating the cyber attack that then it was possible to make legal conclusions that were oriented on a broader interpretation of, let's say, the notion of attack. In other words, it was possible, stemming from the assumption that a cyber operation that interferes with a civilian satellite, shutting down communication, is an attack, to look exactly at what data had been interfered with. So there's always a possibility of the law catching up, at least as technology advances, right?
Okay.
A more realistic answer would be that if the law doesn't catch up, is because launching cyber operation without accountability is strategically very advantageous for states.
Thanks, Giacomo, for that point. I think it's very important to bring in the question of AI and technology and how that actually can impact on our discussion. Thelma, would you like to just close the balls, round off with 1 minute as well, or less? I think you're still muted. Yeah, okay.
Sorry, you meant me?
Yes, Tilman, yes. Would you like to round
apologies.
off? Yes, no problem.
Yeah, on the law catching up, I think conversations like today help a lot in furthering understandings of how the law applies to civilian hackers. But it's also always important to keep in mind that there are fundamental principles that the International Court of Justice has said apply to today's weapons and means and methods of warfare, but also to those of the future. Not targeting civilians, not targeting civilian infrastructure is not that complicated. Not targeting medical infrastructure are very fundamental rules that don't need to be updated. They need to be primarily respected. But of course, conversations like today are important to understand some more of the more nuanced issues that are involved. Educating civilian hackers, probably responsibility for all experts on this call. You may make reference to some of the ICSC material. There's more to come. And maybe on a positive note, when I think about civilian hackers in war, that has existed during the US intervention in Iraq almost 20 years ago, or over 20 years ago. The fight against the Islamic State group around 2014-15 had cyber operations by civilian hackers. But only now it's the time when we have these conversations and bring some of the legal questions to the fore. So we've come a long way, and that's a positive aspect.
Great,
Thanks.
great, Tilman. Thanks. That is the positive to what Kara mentioned was the negative. Samuel, so the quick 1 minute or less.
I might keep on the positive side then. I fully disagree with the idea that big tech can't be held accountable. Australia has been doing so and trying to do so. I think it's a matter of the law catching up. Inevitably, domestic law has to be complied with. Otherwise, there will be fines or there will be a market that they're kicked out of. I think we definitely have quite a wide range of freedoms for big tech at the moment, but inevitably states will start to shut down on that. I think I would describe myself as a tech positivist. You might make it difficult to attribute in cyberspace, but it also, the same technology will in due course catch up, like attribution as a service now that allows states to be able to, in slow time, hire companies to go through and attribute online activity with a minute.
Great, Samuel. That's a great. Xingyu, I have to cut you down to 30 seconds now. Sorry.
Okay. I really want to say yes. It is a really very good sign that the ICRC will take a very clear position regarding the what is the role which have binding force upon the civilian hackers as well as the state responsibilities. That's really very good work. Even if there are some points which are missing, yeah, but nothing is perfect. Nothing is perfect. I think that's the way that how international law and legal practice developed, just like a rolling snowboard. So maybe today, very small board, but maybe 2 years or 3 years later, we may find the rolling snowboard is getting bigger and bigger. And we'll bring more and more issues for us to discuss and practice.
That's also a very positive and optimistic view. I'm going to close it off unless Gaurav has something to add in 10 seconds. If not, then it remains a great delight again to welcome everybody to this, to thank you for your participation. A very interesting discussion. I thought we would have 90 minutes was certainly not enough for the things that the interest that this has engendered. So thank you for your patience, and thank you to everyone online for your patience with our technical issues earlier. As I said, we have an overwhelming response to this, and we've had to expand our Zoom capacity, and somehow there was some glitch on the technical side. But no worries, this is recorded and it will be uploaded for subsequent study, and Giacomo's slides will, I believe with his consent, will also be made available. So a good day, good evening to everyone wherever you are on, and do join us on our next events. Thank you, everyone.